back on the record. 1 second. So, ladies and gentlemen, and I want to make the record clear, defendant's not in the courtroom at this time. Ladies and gentlemen, I understand this is a difficult situation for all of you, and I understand the need and the desire and the inclination to want to respond to things that Mr. Galt is saying here in the courtroom today. And again, it's totally understandable. I can see where you're coming from, but it's really important that this hearing is carried on in a business-like way. And really, it's in your own best interest to ensure that Mr. Galt's sentence is upheld later, and interruptions and problems here in the courtroom are only going to complicate that. So you're not going to be helping your own positions in ensuring that Mr. Galt is sentenced and stays sentenced if there are problems here in the court during this hearing. So I'm going to ask that all of you please try to refrain from making any comments to him, having reactions to things that he says or does, and directing any comments or any outbursts towards him during the course of this hearing. Again, it's going to impede my ability to do what I need to do, what the court needs to do. It's going to impede my ability to make sure that Mr. Galt, that his sentence sticks later. If there are any of you that feel that you can't do that, and again, I understand that, I'm going to ask you to leave the courtroom, to have an opportunity to view the proceedings later if you want to do that. But again, if you don't feel like you can refrain from making comments or having outbursts here in the courtroom, I'm going to ask you to leave. Other than that, we're going to try and proceed again. If you can bring Mr. Galt out, please. Everyone, be seated. Thank you.
Those off of the date of the offense.
Mr. Galt, I've got some instructions for you. I need to proceed with the sentencing hearing today. I need to proceed with the sentencing hearing today without interruptions, unless you are directed or given the opportunity to speak. I'm going to ask that you don't interrupt me. I'm also going to ask that you don't address anyone else here in the courtroom during this proceeding. That's happened already. I'm not going to allow that. If you continue to do that, then I'm going to have you removed from the courtroom and we'll proceed in a different way. Do you understand that?
Yes, sir.
All right. Mr. Gurmurthy, are there any additions, deletions, or corrections to the report?
Judge, there was just 2 corrections to the sentencing information report. That's the last page of the report.
Okay.
It indicates right in the middle in the top portion of the conviction information, the offense date. The amended information indicates that the offense date would be 10/25 to 10/30. I think we should reflect that on the offense date.
Is that correct? Mr.?
It is correct, Your Honor, that we filed an amended information in April of this year that reflects an offense date range of 10/25 to 10/30. So I don't have any objection to that correction.
All right, the court will order that correction then. Any others, Mr. German?
Just right below that, Judge, it indicates scored as of 10/30 of 23. I did speak with Mr. Ziegler about that as well and to the Department of Corrections. I think that the explanation I received is that it automatically puts that date from the original information and enters that in, but I think that needs to be modified as to the date of scoring. It couldn't have been scored that far back.
Mr. Ziegler?
Your Honor, I don't know what that field reflects, whether it's the date that the scoring was done by the probation agent, or whether it means scored as of, as in this is the last date where there was scorable conduct. I don't know, and I don't know that it really matters much in terms of the court's analysis, so I leave it to the court's
Mr.
discretion.
Wagner, can you?
I can't, I was just going back and looking at his old PSI, back from 2016, where it showed an offense date of 11/21 and 15, and that populated as scored as of 11/21 and 15. So the only thing I can think of is like in our system where there was a date range, our last date range was 10/20 of 2023 or 10/30 of 2023. So it picked up that last date, but I could probably go back in this system and reflect it to 10/25 of 2023. Would that be correct?
Well, I think it
Maybe
should,
offense date.
it should say scored as of, again, if the record is just clear, if it's scored as of the date of offense, then it would be that date range in the amended information. If it was scored as of when the report was prepared, then the date on the bottom of the report is 6/5 of 25.
It wouldn't be, it would go based upon the offense date,
Okay, so, yeah, all right,
and it would be, what did he say, 10/20?
5 to 10/30.
right.
Okay, so if that's in the case, if you go back and look at the two previous page, or the second page, second to the last page where it says date of offense,
Mhm.
10/27, 2023 in the BIR,
Yep,
that should probably be changed then to
10/25.
10/25.
Okay, so we'll make those corrections then.
And it might reflect somewhere else as well, but I can make those corrections.
Okay. Any other corrections, Mr. Germer?
No, sir.
Any challenges to the scoring of the guidelines?
No, sir.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
All right, I did receive one victim impact statement that I reviewed. Not sure the pronunciation. I don't know if it's Alice or Alec.
Alec Yeomans, Your Honor.
Okay, so I did review that statement. I know we do have some victims that are present today by Zoom video. Do you know whether any or who would like to make statements today?
Your Honor, I believe Jennifer Yeomans wishes to address the court, and given the setup of the court and the camera over there, I would just ask the court's permission that she do it from the gallery.
Okay, Jennifer, can you raise your hand, please? Okay. You can make your statement right from there if you'd like. And can you just state your full name for the court?
My name's Jennifer Yeomans. I'm Jessica's sister. I guess I was lucky because Jessica would run to my house a lot and they got into their fights to relax. I think that dragging us out is just putting us through hell. You know what you did. They couldn't get one organ to stop bleeding. I would ask that just be sentenced, and I don't want him to ever hurt another person's life. I just don't know how he can sit there and say that he didn't do anything.
Thank you. Any other victims, Mr. Ziegler, that would like to address the court?
I don't believe so, Your Honor.
All right. Anything that you would like to say on behalf of the people for allocation?
Yes, Your Honor. Your Honor, this case has been pending for over 1.5 years. I've poured countless hours into the investigation, the preliminary exam, the negotiations, the trial preparations. I've learned more about internal hemorrhaging and triage procedures than I ever cared to know before. And I will forever have the images from Jessica's autopsy burned into my brain. This has been one of the most violent, traumatic, and callous assault cases that I have dealt with in 8 years as a prosecuting attorney. There is so much to talk about regarding this case, Your Honor, and there's simply not enough time to condense a 2-week trial into a 10-minute elocution. Luckily, the PSI does a very good job of summarizing the facts, but there are a few details I just want to highlight about this case that I think demonstrate why a longer sentence is warranted. First, there's the nature of the offense itself, Your Honor. By all accounts, this was a vicious beating delivered by someone who has a long history of violence. Jessica's own statements, preserved in text, and her final coherent words to emergency medical personnel described it as a 3-day ordeal where she was bruised from head to toe and had multiple black eyes. The EMS personnel noted that her arms were covered in bruises when they arrived to get her into the ambulance. The emergency room nurses, Jessamine Boyd and Nicholas Mitchell, described Jessica as being covered in bruises. Nicholas Mitchell, a registered nurse there, said to Detective Bruzikowski that, quote, "This abuse was the worst he has seen," end quote, in 5 years as a registered nurse in the emergency room. Jessica's pain was so bad that upon arriving at the emergency room, she quickly became incoherent and began thrashing about, something the medical staff described in their reports as pain agitation. To my understanding, that means the pain was so bad she couldn't talk clearly, she couldn't think straight, she couldn't do anything but physically struggle against the pain. The medical records show that when Dr. Strell performed surgery and opened up her body, he, quote, "immediately found 9 liters of blood in the abdominal cavity," end quote. For reference, the human body typically has 5 liters of blood in it in total. They pumped so much blood into her that night, again, quoting Dr. Strell's report, quote, "We had exhausted all our blood product resources," end quote. They pumped every drop of blood that they had available at Munson into her to try and keep her alive. Her injuries were so severe, it was not enough. The autopsy report showed multiple lacerations of the spleen, multiple recent bruises, and signs of strangulation. Probably the only positive thing I will say about the defendant today is that his plea spared the family from having to see these photographs displayed on the big screen here in the courtroom. Suffice to say, they depict bruising all over Jessica's body, to say nothing of the internal injuries. The guidelines can barely account for the significance of the trauma the victim suffered in this case. The second factor I want to address for the court is the defendant's reaction to hearing this news. The defendant didn't rush down to the hospital. He didn't call friends and family to get news. He doesn't go anywhere. He just goes into hiding. He tells multiple people he beat Jessica up, that he gave her a black eye, and he hit her in the ribs, etc. But he's adamant in his text messages that he did not kill her. When law enforcement detains his daughter, Sterling, she admits he's been hiding inside the residence with the door locked and that she's been taking him supplies. She also admits the defendant told her he might have done it, that he hit Jessica in the ribs and it could have caused a puncture or internal bleeding. While the defendant is texting numerous friends telling them he didn't kill Jessica, a few of them mentioned to him that he has home security cameras and that those should help exonerate him, help him show that he didn't do any of this. However, when the police recover the home security system and have it analyzed, they found the system had been overwritten on October 27th and again on October 28th, and no videos before the 28th exist. The defendant proceeds to have an armed standoff with police, where he is in possession of firearms and body armor, and luckily his daughter is able to talk him into coming out of the house and surrendering. The defendant's hiding from police and probable tampering with evidence suggests that he is just as guilty as Jessica claimed he was prior to her death. It also strongly suggests a lack of remorse and a willingness to defy and evade law enforcement. The defendant's behavior and attitude throughout this case has been deplorable. Third, I want to talk about the defendant's criminal history. At a glance, Your Honor, a record of 2 prior felonies and 15 misdemeanors might not jump off the page for this court. I know we've dealt with worse records on other cases in the past, just in terms of quantity. However, on closer inspection, the defendant's record is atrocious. He's quite possibly the worst serial domestic abuser I have ever encountered. The defendant has 5 prior domestic violence convictions and 2 prior assault and batteries. On the surface, that's already bad enough, but digging into his history with his victims reveals that he has repeatedly and continuously abused his domestic partners for over 20 years. The defendant was in a long-term relationship with Kimberly Rootwright. Their relationship produced 2 children. Kimberly told law enforcement the defendant used to be a hard worker, but started abusing controlled substances and started drinking, and he would become violent when he did so. She recounted multiple instances of assaults between the 2 of them. She recounted one incident where she was choked so hard she vomited afterwards. She said the defendant used fear and manipulation to get his way. After Richard and Kimberly broke up, Richard married Krista Galt. Krista had a similar story for law enforcement. Initially, the defendant treated her well, but he abused drugs and alcohol and would become violent. She also indicated that she had been choked by the defendant. They divorced in 2012 or 2013. Defendant then began dating the victim's sister, Rebecca Buck. Buck told law enforcement the defendant would choke her, and he was, quote, really good with the kidney shots, end quote. She told law enforcement she had been given black eyes and bruises by the defendant and had experienced verbal and psychological abuse from him. After Rebecca broke up with the defendant, he started dating the victim, Rebecca's sister, Jessica Scott. Everyone who was asked by law enforcement to describe the relationship described it as some version of rocky at best. Friends, family, neighbors, everyone had some reason to believe the defendant was either emotionally, verbally, or physically abusive with Jessica. Multiple people described hearing them fighting. Multiple people described seeing her with unexplained bruises. In fact, the small detail I found the most telling when talking to witnesses is that multiple people I spoke to told me Jessica often wore long sleeve shirts, even in warm weather. To me, that speaks to the fact that she was being regularly abused, and she was either ashamed to show those bruises or was being emotionally manipulated into keeping them hidden. This murder was the culmination of decades of substance abuse, unresolved trauma, and the normalization of domestic violence in the defendant's life. The defendant has engaged in the exact same behavior with 4 different women over a more than 20-year span. This is just simply the time that the victim bled internally and died as the result of the defendant's abusive behavior. It is not new or unique or uncharacteristic of him. It is exactly what everyone has come to expect from him. There's so many details in this case, Your Honor, I don't have time to fully explore. There's each and every message the defendant sent shortly after the assault to his friends and family, playing the victim. I wish I had time to read them all into the record, Your Honor, because they're a fascinating look into his psyche. I'll just note that to me, they smack of the kind of emotional manipulation others have characterized this relationship as suffering from. There's the fact that the morning Jessica went to the hospital, he messaged his friend Nate Kibbe and said he had to get out of the house before he, quote, killed this bitch. There's the gross manipulation of his daughter, which continued on throughout this case, having her send letters to witnesses, talk to people on his behalf, instructing her to dodge service, having her try to hire another lawyer literally the morning of trial. Just this week, yesterday, in fact, I learned that they have been having jail communications where they were discussing, I'm blanking on this now. They were discussing some things about the case, having Sterling send medical reports, autopsy reports, DNA reports to the victims in this case, the family members of Jessica Scott, including the victims who are potentially going to be speaking at sentencing today, Your Honor, to try and influence, in my opinion, try and influence their statements to the court or to try and soften their views of the defendant. This is just more characteristic manipulation that he engages in. I truly feel sorry for Sterling Galt because she's been a pawn in his games for the last year and a half. And I hope she can one day see what her father has done, not just to the victim in this case, but to her and to her mother and to every woman that he's come into contact with. There's the defendant's stories or excuses he's told other people about Jessica's death. Maybe it was a blood clot, maybe it was an ex-boyfriend telling everyone she was fine when he left the house that morning, while knowing full well what he did to her. There's the picture he posted on Facebook of a highway sign that said lodging next right state prison, and he commented, "Hopefully I won't be seeing anything like that again," end quote. Literally the night Jessica died. I hope I have impressed upon the court one simple fact: the defendant is irredeemable. He is not going to be rehabilitated. He is not going to change his ways. He is not ever going to be a productive member of society. And if he is ever released, he will continue his pattern of preying on women that he has engaged in for over 20 years. That is who he is. Michigan does not have the death penalty for crimes like this, and I've always agreed with that. I don't think the state should have the power to take the lives of its citizens, and I don't accept any philosophical justification for retributive justice. But I do think that for people like the defendant, there is simply nothing else to do with them but to put them in prison for the rest of their lives and make sure they will never be able to do this to anyone else ever again. At some point, the peniological goal of deterrence means that we must prevent this person from ever being able to exercise their free will again, because they have demonstrated they cannot make any decisions that will not lead to abuse and to trauma and to death for their fellow citizens. I don't know what the defense will argue in terms of mitigation, Your Honor, but there is nothing that will bring Jessica back. There is nothing that will excuse the kind of injuries the defendant inflicted on her. The defendant's actions have brought him here. His history of violence before the crime, the brutal and unconscionable crime itself, and the defendant's behavior afterwards all lead me to believe there is no alternative but to sentence him to the maximum term the court can give. I urge the court to fashion a sentence that ensures the defendant will never leave prison until the day he dies. Thank you.
Thank you. Mr. Grimmerty, anything on behalf of Mr. Galt?
Does Mr. Galt, in lieu of preserving his rights, has asked me not to allocute on his behalf, so I don't have anything to add or allocate on his behalf.
Mr. Galt, is there anything that you wanted to say? The record should reflect Mr. Galt was shaking his head no. I obviously had an opportunity to review the pre-sentence report. We've had a lot of different motions in this case reviewed, as I indicated earlier during this hearing. The transcripts from the preliminary exam that was part of the plea process, but I reviewed it as well as part of my consideration in sentencing. I've reviewed the file. Obviously, I've reviewed the pre-sentence report, which gives a very detailed account of the relevant facts in this case, and also provides a lot of information about you and your background, Mr. Galt, and your history and so forth. I do want to thank Ms. Yeomans for making a statement that she made here today. I always think it's important for victims to stand up and make a public statement, as difficult as that can be, especially under these types of circumstances. Number one, I think it's important for the court and the public to hear it. And number two, I think it's important for other victims to hear when they see someone have the courage to stand up and make a public statement about how a crime has affected them. So I appreciate your comments and the letter that was written and the other individuals that have appeared on behalf of the victim in this case. The prosecutors talked a lot about the aggravating factors here, and I don't think I need to go through those again. I don't think certainly the victim's family doesn't need to hear about it again. You're well aware of your conduct, Mr. Galt, and what you did to contribute to the death of Ms. Scott in this case. A judge that I respect and admire and has been a mentor to me once told me that the more heinous a crime is, the less a judge has to say at sentencing, because it's self-evident the effect that it's had and the degree of depravity that has occurred. And I think the facts as laid out by Mr. Ziegler during his allocution clearly established that. I also think from the standpoint of rehabilitation, your record is an absolute indicator to me that there is no possibility for your rehabilitation, Mr. Galt. You have engaged in this type of abusive conduct towards other individuals and towards your domestic partners, as Mr. Ziegler indicated, for over 20 years. I counted 6 prior domestic violence convictions and 5 prior assault and battery convictions. You've had 10 prior jail sentences, 2 prior prison sentences. You've been on probation for 8 times in your 56 years. That to me indicates a long pattern, a long history of engaging in the same conduct over and over again towards different partners. I fully agree with what Mr. Ziegler had to say in the sense that this unfortunately was the last individual that you had an opportunity to have access to and to abuse. And this, I think, could have happened to any of your prior partners. It happened to go too far in this case, but I think it could have happened in any of those other cases, and they're all probably lucky that it didn't. Unfortunately for Ms. Scott, she was not. I'm fully convinced that if you were ever to be released and engage in another domestic relationship, you would engage in this exact same conduct. And for those reasons, for the safety of the public, the safety of the community, I do think that a jail prison sentence at the top of the guidelines is absolutely appropriate. I think it's important that you're never allowed to have access to another individual again, that you have the opportunity to abuse in the way that you abused Ms. Scott and the other women that you've been involved with throughout your life. So for all those reasons, the court finds, again, that a sentence at the top of the guidelines is appropriate. The court will sentence you to 450 months. That's 37.5 years to 60 years in the Michigan Department of Corrections. You do have credit for 617 days served. There will be a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of the sentence. Provide you with acknowledgement of those appellate rights. Murphy, if you can provide that.
Yes. Just for the record, Mr. Galt has his appellate paperwork with him.
All right, thank you, Mr. Galt. You are remanded to the custody of the state this time.